Good morning, everyone. I'm going to dive right in because I think you get a break right after. Yeah, you get a break right after I'm done. So let me dive right in so that you guys can get to your break sooner rather than later. So I'm David Goldstein, a partner at Certilman Balin Law Firm on Long Island, and my practice is limited to nonprofits and religious corporations. I'm also the chair of the State Bar Committee on Not-for-Profit Corporations, and we're going to be talking about nonprofit governance, and in particular, some traps for the unwary, common mistakes that nonprofits make, and also we're going to talk about some recent changes in the not-for-profit corporation law. So just some housekeeping before we dive in. Everyone's got a booklet of my materials. If you're on the webinar, we will be emailing these to you later. So in addition to the PowerPoint, there's some supplementary materials that will tie into some of the items we're going to be speaking about. And the first thing we're going to do is we're going to do a quick governance blitz quiz. It's starting on slide 3 of tab 1. So if you open to tab 1 of your booklet, there are 5 questions starting on slide 3. I'm going to give you a couple of minutes to do those. And for people on the webinar, I'll be going through those on your slide, so you'll be able to see the questions that everyone's answering. So go ahead and get started on those 5 questions in tab 1. Okay, good. So I think we've given everybody time to finish the questions. So let's talk a little bit about some traps and mistakes that commonly affect nonprofits. So here's the most fundamental trap, and what very often comes as an extremely unpleasant surprise for nonprofits and the directors and officers. And that is that directors and officers of nonprofits in New York have legal duties. These are commonly referred to as fiduciary duties. That's part 1. Part 2 is even more unpleasant, that in fact, under the law, there is personal liability to directors and officers for breaching those legal duties. So what are the fundamental legal duties of a nonprofit director under New York law? There are 3 fundamental legal duties: the duty of care, the duty of loyalty, and the duty of obedience. And we're going to unpack each of those one at a time. The duty of care, and these are going to tie into the questions that you just answered in our little blitz quiz in a minute. A director has to act in good faith using the degree of diligence, care, and skill that a prudent person would use in a similar position under similar circumstances. And basically what this translates to is this is the board oversight function. Diligent oversight of the nonprofit and its assets and its activities. And if you think about that for a minute, that's going to require familiarity with the organization's finances and activities and regular participation in its governance. And that sentence is worthy of being repeated because, in fact, it comes from the Attorney General's guidance, parts of the Attorney General's guidance on board fiduciary duties. The duty of care requires familiarity with the organization's finances and activities, and also regular participation in its governance. So if you're on a board and you don't go to meetings, you've breached your duty of care. The duty of loyalty. A director has to act in the interest of the organization. This requires undivided allegiance to the organization's mission when using the power of the director's position or information concerning the organization or its property. And where we most commonly see the duty of loyalty come into play is in the area of conflicts of interest and related party transactions. And I'm sure if all of you are in the nonprofit world, you've heard a lot about that in the last couple of years. This has been a major focus of New York law and also enforcement and also private disputes involving nonprofits. The third of the three fundamental duties of nonprofit directors and officers is the duty of obedience. So this is actually the least understood and the most often neglected of the three primary legal duties. And basically this is because the other two legal duties exist in the for-profit world, but the duty of obedience is only applicable to nonprofits. The duty of obedience is a fairly complicated process. It has a few different pieces. One of the primary pieces is to ensure that the organization complies with applicable laws and regulations and also its internal governance documents and policies. So compliance with laws and regulations is really multi-tiered and very burdensome because you're not talking just about federal regulations, you're not talking about state, you're talking about county, local. So there's a multi-layered constellation of laws and regulations that as a nonprofit director or officer, you're responsible, A, for knowing them, and B, for complying with them. That's one part of the duty of obedience. If that wasn't enough, the other part of the duty of obedience is that you've got to comply with the internal governance documents and policies of the nonprofit. And here too, there are multiple layers. So let's start with the most basic document of any nonprofit, and that's its certificate of incorporation. It's your charter from New York State. It's the document that creates the corporation and it gives it authority to exist and operate. And it, in fact, is a contract between the organization and the state. And most significantly, the corporate purposes of every nonprofit are set out in its certificate of incorporation. So in red, it's important to remember that there's potential personal liability for board members for failure to strictly adhere to the corporate purposes. And this next statement too comes from the Attorney General's guidance. And it says that a diversion from corporate purposes, no matter how worthy, is a breach of fiduciary duty. So it's imperative as a nonprofit board member or officer that you're aware at all times of what your purposes are, because your activities and your use of assets is limited strictly and exclusively to those purposes. And this is, in fact, leads to a trap that many nonprofit directors and officers fall victim to. The first document in your organization's history is its certificate of incorporation. Literally, that's the document that begins the corporation's life. Nonprofits very often file the certificate of incorporation with the Department of State and then file it away in a drawer, in a cabinet, on their server. And in fact, this is a very dangerous practice and can be a very costly one. The corporate purposes are in the certificate of incorporation, and failure to strictly adhere to those purposes puts the individual directors and officers at risk for breach of duty and personal liability. So that brings us to our first question in your Blitz quiz. And this talked about the Neighborhood Community Center that was founded in 1940 and was operating an athletic facility for youth in the neighborhood. Demographics changed in the neighborhood. There aren't any more youth, and the board was sitting with an empty youth athletic facility. So the board decides to convert this athletic facility into a center for seniors that serves as a soup kitchen and food pantry as well, and performs a life-sustaining role in the community, serving hundreds of members every day. The question was, did the board act properly under not-for-profit corporation law? And the answer is unequivocally no. The board breached its fiduciary duty because its corporate purposes in its certificate of incorporation was limited to running a youth athletic facility. So again, here, this would expose the directors and officers to personal liability under the law. It's important to note that there are procedures for amending your corporate purposes in the law, but these are very complicated and detailed procedures. And for a charitable nonprofit to amend its purposes, it requires Attorney General approval. And a big piece of the Attorney General's analysis is what's known as the quasi-CPRE doctrine. And basically there, the Attorney General is looking to make sure that assets that were raised or acquired for a particular purpose are used for that purpose. So amendment is possible, but it's not quite as easy as it sounds. There's a regulatory process involved. Okay, next, bylaws. Bylaws are the contract between the organization and the board, and if you've got a membership organization, the bylaws are a contract between the members and the board and the organization. And basically, it lays out how the organization is going to operate. It's really important to remember about bylaws is they're not reviewed by any regulators. So when you incorporate and you register with the Attorney General, if you're required to do that as a charitable nonprofit, you submit your bylaws to the Attorney General, but nobody reads them and nobody looks at them. Bylaws, in fact, are very easy to amend. You can amend them at pretty much at any board meeting. And they're actually a little too easy to amend because you can change them, again, without any regulatory oversight. So it's important to remember that bylaws provide a roadmap to legitimize corporate decisions, and it's vital to follow that roadmap to protect directors and officers from potential liability. So bylaws, again, can be written ad hoc at any meeting of the board. They can be amended. So it's really important that amendments are done in coordination with your legal counsel, because the bylaws don't stand on their own. They need to comply with some of the mandatory provisions of New York law, and we're going to get into that in some of the hypotheticals and the questions in a minute. So remember that that the bylaws are a piece of the duty of obedience. So failure, number one, to follow the roadmap in your bylaws is a breach of the duty of obedience that exposes the board and officers to liability, number one. And number two, the bylaws themselves need to comply with the law, and that's also part of the duty of obedience. So governance mistakes in this area are very common, and let's look at question number two, which had a board of 7 directors, and the bylaws have a provision that states very clearly that if the board wants to make a decision without a meeting, if 6 of the 7 directors consent in writing to that decision, the decision becomes an action of the board. And so is that a valid provision? And if the board acts under that provision, is the board acting validly? And the answer is no. And this is an actual fact pattern I had. I had a client come to me when they were already in litigation. And one of the issues in the litigation was they had this very provision written in their bylaws. And the law stipulates that there are 2 ways for the board to act. One is at a meeting, and the other is by unanimous consent without a meeting, the operative word there being unanimous. So 6 of the 7 directors, even though the bylaws said that that was sufficient, that is insufficient under the law, and any action taken based on that bylaw is a breach of the duty of obedience. And again, I had a client that where the board was sued personally for expenditures that were made approved by 6 of the 7 directors, consistent with the provision in the bylaw, but in fact, it was violative of the law. Okay, questions, anyone? Okay, question 3. In question 3, the director gives a proxy to another director to vote the director's vote at a board meeting. And again, this is consistent with a provision in the bylaws that says that one director can give another director a proxy. And question is the proxy effective? And again, the answer is no, notwithstanding the clear provision in the bylaws that says you can do this, the law says you can't. Members of a nonprofit can give proxies, but directors can never give a proxy. And part of the reason for that is what we discussed earlier, that directors have fiduciary duties and personal liability. So because of that, they can't give someone else their proxy. Basically, because they're stuck with the responsibility at the end of the day, they can't give their vote away. Question?
Well, my only question is, why would such a bylaw have even been passed?
Okay, and I'm going to repeat the question. The question is, why would such a bylaw have even been passed? and part two of your question is, didn't counsel review it first? So two issues there. A lot of times, yeah, okay. A lot of times nonprofits amend their bylaws without passing it by their counsel, number one. So that is a slippery slope that inevitably leads to problems. Number two, very often their counsel is not experienced in not-for-profit corporation law matters, and so what may sound like an intuitive provision that sounds okay, but in fact there are provisions in the law that that mandate that you can't do it that way. So good question, and the practical reality is that that these kinds of things happen in the nonprofit context all the time, and that's part of why I want to flag it for you. Okay, question 4. This asks whether if there's a provision in the bylaws that says that a board can act by email via unanimous consent of all the board members, would that work? And the answer is absolutely yes. In 2014, the not-for-profit corporation law was updated to allow for use of email, including email consent. But the trick here, and the trap that that victimizes a lot of nonprofits when they use this provision in the law, is that the consent needs to really be clear and unambiguous. So email is something that we all use, and we're used to a lot of informality in an email. But if you're using an email consent, that consent is a legal document, and for it to be a valid consent, every director has to consent unambiguously. So if you've got 10 directors and 9 of them respond and say, I consent or I agree, those 9 are good. But if the 10th director responds and says, I agree, but why were we so generous in paragraph 10? That's not a consent. That then becomes ambiguous. It's not, it doesn't rise to the level of a clear consent. So that's an area that we need to keep our eye on and maintain discipline. In question 5, this is another area where the provisions of the law are somewhat counterintuitive. So a director resigns from the board with 2 years remaining on his 3-year term. The board, under the bylaws, votes to appoint another director to fill the vacancy for the remainder of that term. Is this valid? It absolutely is not valid, because under the not-for-profit corporation law, there's a mandatory provision that says the board can only fill a vacancy until the next annual meeting. So, so when you fill a vacancy beyond that, what you've done then is call the composition of your board into question. And that can be used to delegitimize corporate actions that the board takes because the board isn't properly constituted. So what was Director Don, who's filling the vacancy, what was he even doing there, because he wasn't properly on the board? So the risk of mistakes in these areas is that decisions can be challenged after the fact, and there can be potential personal liability to directors for improperly taking decisions. Yeah, question.
Yeah, I have a question. What happens if the bylaws don't have any term for the directors and thank you. Okay, what happens if the bylaws don't have specific terms for the directors and the board votes to appoint the director to replace one who resigns? Do they have to do something in the next annual meeting to confirm that appointment?
100%. Any vacancy can only be filled until the next annual meeting. You said it exactly. The vacancy gets filled up until the next annual meeting, and then it's got to, if it's a membership corporation, the members need to act, or if it's a board-run nonprofit, the board needs to act. So we're now going to talk about conflict of interest policies, and this again relates to the duty of loyalty, which is the second of the 3 fundamental duties of nonprofit officers and directors. Prior to July 1st, 2014, New York nonprofits were not even required to have a conflict of interest policy. Most did, it was a best practice, but it was not required under New York law. Effective 7/1/14, every New York nonprofit has to have a conflict of interest policy, but not just any policy. It's got to be the policy that New York law mandates and that meets the very specific requirements of the not-for-profit corporation law. And in fact, the sample conflict of interest policy that the IRS puts out is absolutely inadequate under New York law, and it would be a breach of the fiduciary duty of everyone on the board if you use the IRS policy and you're a New York nonprofit. And many before July 1, 2014, my sense is most New York nonprofits used the sample IRS policy in one form or another. Absolutely doesn't work anymore. New York law is far more demanding than what the IRS suggests. So let's talk about some potential traps in the area of conflicts of interest. I've had boards take the position that conflicts of interest are bad in and of themselves. We just can't have them. And so we're gonna have a practice that if there's any situation in which a board member or an officer has a conflict, we won't entertain proceeding with that transaction. And that is really not the right reading of the law. In fact, the Attorney General has said that they want organizations to engage in transactions where there are conflicts of interest, because if they don't, they're limiting themselves and maybe depriving themselves of benefits. And you can think of lots of examples of that. Lots of times someone on the board is offering something to the nonprofit at way below market rate, and we don't want the nonprofit to be deprived of that benefit. What New York law does require is that when there is a conflict, we follow very specific and detailed procedures. Another potential mistake that nonprofits make, that we've got a great conflict of interest policy. It was written by a lawyer. Don't worry about it. We're good. We're covered. The standard is not that it's a great policy or that it was written by a lawyer. The standard is that it complies fully with the meticulous procedures and requirements that are now mandated by New York law. And remember, it's a violation of the law and a breach of the fiduciary duty of every board member and every officer if the policy doesn't comply. So even if I'm on a board and I'm not benefiting from, if there's no conflict involving me, it's still a breach of duty for me personally and exposes me to liability if our conflict of interest policy doesn't comply with the law. Next, we've got a great conflict of interest policy. It was written by a lawyer, and guess what? It complies fully with New York law. So we really don't have to worry, right? You still have to worry. It's not enough to have a perfect conflict of interest policy. Many nonprofits have a perfect conflict of interest policy, but they don't maintain the governance discipline to carefully comply with all of the detailed and demanding requirements and procedures under that policy. And again, failure to comply is a breach of fiduciary duty for every board member and every officer. So just to give you a sense of some of the details that have to be covered in your conflict of interest policy and that you've in fact got to follow, disclosure of conflicts has to happen before a director is elected to the board for the first time. So that's in advance of their election, at least annually, and at any time that a conflict arises. So this is an ongoing responsibility. It's not a one-time endeavor. By definition, it's got to happen at least annually, even if there's no conflict. The policy is very broad. It covers entities that directors, officers, or key persons have a certain level of interest in, and also, and this is something that trips up lots of nonprofits, it's got a very broad definition of relatives, and relatives are covered under all of these rules. So the New York statute requires you to go as far as spouses and domestic partners of great-grandchildren. They would be considered relatives who trigger the conflict requirements. If you're a director and the domestic partner of your great-granddaughter has some sort of a transaction with the organization, that triggers the conflict of interest requirement. So that's something to keep an eye on. Also fundamental to this whole conflict of interest regime is that there are different levels of conflicts with different procedures. So there's a basic garden variety conflict of interest, and that may be a situation where if I'm on a board and my wife happens to be on the board of a library, and the board of my nonprofit has a program with the library where my nonprofit is funding this program at the library, that's a conflict of interest because I may have an allegiance that runs counter to my allegiance to the organization because my wife is on that other board. It's still a conflict even though there's no financial interest in it from me or my wife. The other type of conflict is known as a related party transaction, and that is a type of conflict that has enhanced procedures and receives enhanced scrutiny under the law, and that's because it's basically a financial situation where a director, officer, or key person has a financial interest in a transaction. And so there's a whole slew of additional requirements that you and your counsel need to be aware of and meticulously follow when there's any sort of financial transaction being proposed. And the last bullet point highlights the words, magic words. For these related party transactions, literally the statute requires magic words. The board has to make an affirmative determination that the transaction is fair and reasonable and in the best interest of the corporation. So if the board follows all of the other requirements of the statutes, disclosure, the fact that the person with the conflict can't be present during the deliberation or voting on the transaction, and a bunch of possible assessing alternative transactions. If the board does all of that and then just approves the transaction, but doesn't recite in the magic words in the resolution that the transaction is fair and reasonable in the best interest of the corporation, then you've blown compliance and the approval is improper. So, yeah, question.
Let's take a step back regarding conflicts of interest with relatives. Is that include siblings?
Yes, absolutely. So here's the question. I'll repeat it. Does the conflict of interest provisions, do they include siblings in the definition of relatives? Absolutely, absolutely. Siblings, in-laws, it goes all the way to great-grandchildren and their spouses and domestic partners. So it's as broad as you can imagine in terms of relative. Okay, so we've seen then that under the not-for-profit corporation law, we've got all these hyper-technical requirements, and we've also got lots of requirements that are counterintuitive. And that in and of itself sets up a potential trap because lots of nonprofits are really interested in having lawyers and accountants on their boards. And I haven't done a scientific survey, but interestingly, the boards that I represent, and again, my whole practice is nonprofits, I can think of a bunch of instances where there's a fairly large board, bunch of lawyers, bunch of accountants on the board, and some of those boards are the most poorly governed boards that I've seen. So, while the training and the skill set and the issue spotting ability of lawyers and accountants is wonderful, it's really perilous to rely on them to be able to get their arms around some of these very hyper-technical and counterintuitive legal requirements unless they really specialize in this area of the law. Probably 70 to 80% of my practice is cleaning up what very well-meaning lawyers and accountants have managed to screw up before they got to me. So, and it of course, as with most things, had it been done right from the start, it would have been simpler, cheaper, easier, and it's much more expensive to clean it up a few years down the road. Another issue, and I'll just touch on it briefly because I want to make sure we get to some of the changes in the law. A lot of nonprofits try to compartmentalize in their relationship with their attorneys. So a few years ago, I had a client come to me and ask me what I thought of paragraph 42 of a particular agreement. And I told them what they should do to fix paragraph 42. And I asked if I could help with the rest of the agreement. They said, absolutely not. 3 lawyers on the board went over it, drafted it. It's fine. It's wonderful. Don't look at anything but paragraph 42. So, fast forward 3 years later, and, paragraphs 1 to 41 have blown up. And so, compartmentalizing isn't a good idea. I've found that nonprofits shoot themselves in the foot when they're limiting their engagement with their lawyer or accountant to very specific provisions and not letting them get involved in the bigger picture. Okay, I want to hit quickly on some of the changes in the law that went into effect just a few weeks ago on May 27th. And we're not going to hit all of them, but we're going to try and hit some of the highlights. And these amendments were targeted particularly at addressing some of the most egregious practical difficulties and unintended consequences of the changes in the law that went into effect in 2014 around conflicts and related party transactions. Basically, as very often happened, the law was reacting to lots of fact patterns and stories in the news, and went a little bit too far in that reaction and created situations that were unmanageable on the ground. So the State Bar Association and some other groups, legal groups in the nonprofit sector, worked with the Attorney General and the legislature for a couple of years to try to rationalize some of these provisions and make them more manageable. And I'm going to skip a little bit, and I'm going to touch on, so we talked about related party transactions, and one of the problems with related party transactions is that there was no financial cutoff. So even small and insignificant transactions that ordinarily wouldn't be reviewed by the board triggered all of these related party provisions that we were talking about earlier. So if you've got a board member who's a plumber, and you've got a $100 bill from that plumber for parts, it would have been a $1,000 repair that someone else did. He's just charging for the parts. That's a financial transaction with a board member. It's a related party transaction, and before May 27th, that would have kicked off all of the requirements for related party transactions. You would have had a board meeting to vote on it. There were quorum requirements and voting threshold requirements, and it was nuts. So one of the main things that the May 27th amendments did is they created appropriate carve-outs from the definition of related party transaction, and so included in those carve-outs, and one of the most significant ones is what the statute now refers to as de minimis transactions, basically a transaction that's of limited monetary value. So take my $100 transaction with the plumber who's on your board. That, because it's of limited monetary value, is no longer a related party transaction, so we don't have to worry about all those onerous procedures for that transaction. And there are other carve-outs as well, and you can look at those in your materials. One of the other requirements that was pulled back a little bit is that under the law before May 27th, any conflicts of interest had to be handled by independent directors, and that was also a very complicated and burdensome requirement, and basically that's been removed, and now the requirement is that if there's a conflict or a related party transaction, it has to be handled by a disinterested director, and that makes sense, right? I mean, I can vote on a conflict if I'm not involved with it. Okay. So one other thing to be aware of in the May 27th amendments is there's now a new process where, under very limited and specific circumstances, you can retroactively approve, and the legal term is ratify, a related party transaction that happened in the past that you might have missed, that you blew, and you didn't handle it the right way. It's not a get out of jail free card. It doesn't work in all situations. There are specific requirements, but it's great to know that if you inadvertently failed to deal with a related party transaction the right way, you can fix it retroactively under certain circumstances, and that's also something to talk about with your lawyers if that triggers anything in your recollection. So the amendments, the May 27th amendments, also made it easier to form and populate board committees, and so that's an area. So all of these changes, in virtually all of the May 27th changes, were beneficial to nonprofits and made the bar for breach of duty lower, made it easier for nonprofits to comply. So it's really important that your conflict of interest policy and your bylaws be amended to take advantage of these favorable provisions, because if the law requires this level of compliance, but your bylaws have not been amended to reflect that, and they're up here, then you're held to that higher standard. So really important to make sure that your council has amended your conflict of interest policy and your bylaws to take advantage of these more favorable provisions. And that again, will limit some of the areas where board members and officers can find themselves targets and have potential personal liability. One other provision that I'm really happy about in the May 27th amendments, as we were looking through some of the provisions in the law that we wanted to amend, we noticed that there was a provision that said that a volunteer member of an advisory committee, so not a director or an officer, someone who has no authority and who gets put on an advisory committee to the nonprofit, had the same level of fiduciary duties and thus the same potential liability as an officer of the nonprofit. And that was really a crazy provision, and we pushed very hard to get the Attorney General to agree to ask the legislature to remove that provision, and that's one of the key amendments under the radar. Most people aren't aware of it, but that's one of the key amendments that went into effect on May 27th, is that that liability for volunteer members of advisory committees has been eliminated.
Dave, I have one question. I mean, volunteers can serve in multiple roles within the organization. They can be both an advisory committee, but they also can be the provider of services on behalf of the organization. You know, Girl Scout troop leaders. So, do you think that any agreement that you have volunteers sign should differ depending on whether you're an advisory capacity or really in the position of carrying out the organization's mission?
Okay, so yeah, the question is, and I'll sort of paraphrase a little bit, in terms of volunteers, how do we handle them? Volunteers can have different levels of engagement in the nonprofit, and the question is, how do we document those, and how do we control those? And that's a really important question. It's a loaded question. There's only so much that you can delegate to volunteers, so that's number one. So you've got to have internal procedures that limit that. There are lots of issues with volunteers. For instance, in terms of fundraising, you need to be really careful, because when you're fundraising, you're creating contracts, even if they're verbal, between you and the donor. And so are volunteers out there creating contracts that you don't even know about, that later the organization and the board can wind up in litigation over. So that's an area that's fraught with dangers, and you really need to very carefully monitor it, both on the board level and with your counsel. Okay, well, another question?
Regarding related party transactions, has the amendments addressed the situation where you have a brother-sister not-for-profit to not-for-profit corporation, essentially the same board of directors? How do they operate, given the related party rules?
So the related party rules are not directed to that situation, but for sure that involves conflict of interest and fiduciary duty. So again, that's a question that has to be unpacked based on the facts and circumstances of each situation. But you're absolutely right that there are conflict of interest questions there, because just on the most obvious level, you've got to, if you're on the board of both, you've got a fiduciary duty to both, and how do you balance that? So that's definitely something you need to keep a very careful eye on. Okay, good. So I'm gonna cut it off there. The last thing I'm gonna say is that you have in your materials information about the July 1st, 2017 increase in the threshold for an audit from 500 to 750,000, and there's lots of other supportive documentation in your materials. If you look at the table of contents and thumb through it, you'll get a sense of how that ties into what we've spoken about. Thanks very much.